Hi, hello everyone. My name is Anas Shahid bin Muhammad Halili and I am from Group 13. And today I'll be talking about the Magistrate Court and the history behind the establishment of the Magistrate Court in Malaysia. So firstly, let us go to the introduction first, shall we? The word magistrate goes back to the Latin word magistratus, which carry the meaning of administrator. Administrator is a person who carries out the law, or a judge who had the authority to conduct a court. Magistrate court or the jurisdiction of the magistrate and session court judges were established in Peninsula of Malaya through the Subordinate Act in 1948 under the Federation of Malaya Agreement 1948. Magistrate courts only deals with minor civil and criminal cases only. For example, the civil claims that are here in the magistrate court are cases that are below Rm 25,000 ringgit. Not only that, criminal jurisdiction is where the maximum punishment is the imprisonment that does not exceed 10 years or by fine only. The cases that are usually here in the magistrate court are low cases such as property damage, traffic violation or breach of trust, which mean that high-level cases such as ship hijack or criminal code or murder will not be here in these magistrate courts. Next, we go to the history of Malaysia First Court. The legal system in Malaysia began on 11 August 1786 in Penang, because Penang Island that time was a leading trading center with a rapid population growth. It all started with the conquest of Prince of Wales, or we call it as Penang, by Captain Francis Light. At that time had to seek help from the Governor General of India to help him administrate the inhabitant of the Penang. In 1801, Malaysia then experienced a setting up a formal modern court system when John Deacon was appointed as the first local magistrate in Penang. He was appointed and tasked with resolving dispute and administrating the law. And as the demand placed on him, he became increasingly onerous. Then, in 1807, the Royal Charter of Justice was awarded to Penang in order to manage the growing immigrant population, and this gave the right for the establishment of the police force and a court of justice. The Royal Charter of Justice was granted from the East Indian Company with the authority of King George III from the British. And this authority has given birth to the establishment of the first Supreme Court in Malaysia. In Malaysia, the courts are divided in two groups, which is the High Court and the Subordinate Court. The High Court starts with the Federal Court as the highest court in the hierarchy and ending with the Magistrate Court as the lowest court in the hierarchy, which is the Subordinate Court. There are two reasons behind the existence of the hierarchy courts in Malaysia. Firstly, to distinguish between the higher and lower court so that the people know which court held the most or the highest jurisdiction in Malaysia. Secondly, allow an appeal to be made if the decision decided by the court was wrong or is invalid. Even though we had many other courts in Malaysia, but still, Magistrate Court still had some other important or benefit from it as a subordinate court. Firstly, the Magistrate Court can only hear the simple civil or criminal cases in order to reduce the burden of other courts in handling the case. Not only that, by handling the civil cases, it will help the citizen in need And thirdly, it will help the citizens to follow the procedure and resolving the cases and the problem. And what we need to be taken note is that magistrate court only had the power of imprisonment, cane whipping, and fine only. That's all.
Assalamualaikum. My name is Nur Zulaika binti Rizal Hisham with matric number 063740 from group 13 are going to present about the jurisdiction of the magistrate court. The magistrate court are established under section 76 SCA 1948. They may preside by the first or second class magistrate. Both of the magistrate classes are appointed by Yang di-Pertuan Agong in the federal territories by the ruler or Yang di-Pertuan Negeri in the state. The magistrate court has comprehensive authority to resolve civil and criminal issues that arise within the local limit of the jurisdiction allocated to them, or in any part of the local jurisdiction of the respective high court if no such local limits have been set. They may also issue summons, warrants, or other processes in order to make any interlocutory or intent orders such as orders for enjoyment, remand, or bail. They may also conduct theft investigations based on specific jurisdiction. This situation is determined by the magistrate court standing. For example, in case Lee Heng Kui v. Public Prosecutor 1993, 1 MLJ 69 held that under Section 40 Clause 1 of the Interpretation Act 1967, Section 87 confers upon a first class of the magistrate the power to impose among others. This includes jurisdiction to try offences, which permits for wiping to be used by a magistrate under the SCA 1948. The first class of magistrate has appellate jurisdiction to hear and determine civil and criminal appeals from any division of the Penghulus Court within their local jurisdiction.
Establishment of Magistrate Court. Malaysia has a constitutional monarchy which is headed by Yang di-Pertuan Agong, who is a formal head of three branches of government, which is legislative, executive and judiciary. Judiciary is divided into two levels, which is federal level and state level. Magistrate Court is under subordinate court at federal level along with Sessions Court. In Malaysia, Magistrate Court is the lowest of any other courts and it is numerous. Magistrate Court is established under Section 76 of Subordinate Courts Act 1948 and it is divided into two classes, which is first class magistrate and second class magistrate.
Kind of cases that the magistrate court deal. Any person that has been charged with criminal offence must be brought at the magistrate court as soon as possible. The first kind of cases that the magistrate court deal is less serious offence, which is summary offence. For example, it's traffic infringement, such as if a person has committed traffic offence, he or she may be issued of traffic infringement. In some other cases, they may also come with court notice that will make he or she must appear at the magistrate court to deal with that matter. The second type of cases that the magistrate court deal with is minor offence. The example of minor offence is disorderly behaviours or shoplifting. If he or she commit this kind of offence, their cases will firstly appear at the magistrate court. If some circumstance is if the offence is serious, the case will be sent to the higher court to handle the cases. And lastly, the type of cases that the magistrate court deal is more serious offence. The example of the more serious offence is like burglary, assault, and fraud or drugs. In this type of cases also will be settled by the magistrate court, because the magistrate court jurisdiction is expanded in some circumstances to hear more about the serious offence.
Advantages of magistrate and their juries. First, they involve ordinary people. It can benefit local people in understanding law better and give them experience about how the court works. Second, the cost is cheaper than using professional judges as they work voluntarily. So if you intend to plead guilty, you should keep your case in magistrate as you are likely to get a low penalty. Third, it consists a good gender balance. It can benefit both genders because they can understand men and women well. Lastly, the magistrate have knowledge of their local area. They may be more aware of the crime hotspot, and it can lead to community concern which their interests can be represented in helping the decision making of the case. The disadvantages of magistrates and its juries. First, they lack formal legal qualification. Anybody can apply to be magistrates as there is no qualification required to be lay magistrates. Therefore, they will probably have no law qualification and not much knowledge on the law. However, they are still trained. Second, they prosecute and police bias. This happens when they are sitting in local areas, so they get to know the police officers that come to give evidence. They tend to be more sympathetic to them. They tend to be more sided with the prosecution and police that they could sentencing someone innocent. Third, they rely too heavily on the advice of the clerk. The clerk cannot help in decision making as they are not qualified or at least trained. It could affect the best decision making. And last but not least is inconsistency in sentencing. Magistrates from different areas will have different opinions on the same offence, so the offenders can get different length of time on the same offence. Because it is from different opinions from different areas, the process to reach a decision can often be slowed.
Judge is a person who presides over court proceedings either alone or as a part of a panel of judges. The judge hears all witnesses and other evidence presented by the barristers or solicitors in the cases, assess the credibility and arguments of the parties, and then issue a ruling in the cases based on their interpretation of the law and their judgment. A judge also needs to conduct the trial impartially and typically in an open court. The powers, functions, method of appointments, and the training of judges vary widely across different jurisdictions. In some of jurisdictions, the judge's power may be shared with a jury. To become a successful judge, a person needs to obtain an undergraduate degree. There are three types of judges. Firstly, Federal Court Judges. No specific criteria for becoming a federal court judges. Most have obtained a law degree and spent time practicing law. There are two types of federal judges. Federal court judges. First, magistrate court judges. Magistrate court is a part of the US district court system. This means that there are special courts created by Congress and only certain types of criminal and civil suits they handle. Judges are appointed by the President with the consent of the Senate. Second, Supreme Court Judges. Supreme Court Judges is in the DC and it is comprised of 9 justices. 1 Chief Justice manage the others. There is no term limit and these appointments are usually made after a long debate in the Senate. Next, State Court Judges. They are allowed to determine their own rules of appointing and hiring judges. They can be appointed directly by the state government and legislature. And the last one, the Administrative Law Judges. They oversee decisions concerning administrative hearings and concerning benefit granting agencies and regulatory. The longest employee of these judges is Social Security Administrative.